Good afternoon. I'm Peter Bartinik, a board-certified civil trial attorney practicing law here in Connecticut. Today we're going to talk about the Family Medical Leave Act and a key distinction between proving an entitlement claim and a discrimination claim. So first, generally the Family Medical Leave Act provides for a certain amount of unpaid leave for a qualifying condition, and there are two Family Medical Leave Acts that are relevant to Connecticut. One is the Connecticut Act and the other is the Federal Act. But for purposes of today, what we're talking about is the proof required for a claim under the Family Medical Leave Act. So you've got two types of claims under the Family Medical Leave Act, which one would be a discrimination claim where you're claiming that your employer has discriminated against you in some fashion or retaliated against you for exercising your rights under the Family Medical Leave Act. For example, if you take time off and they give you the time off, but for some reason you find you're treated differently after the fact and you're treated differently in a significant way, for example, you're fired, that would amount to a discrimination claim or retaliation claim, you'd call it. And in that type of case, you need to prove an intent to discriminate. So you need to prove that the basis for the discrimination against you was because of the fact that you exercised your rights under the Act. You've got to prove that intent on the part of the employer in order to win that case. So compare that to a different type of claim under the Family Medical Leave Act. It would be an entitlement claim. In this type of claim, you're not trying to prove discrimination. Instead, you're proving that you weren't given the rights you're entitled to under the Act. For example, you took time off and the employer didn't let you come back to the position, or you weren't given the time off when you were entitled to it. So you were denied the benefits under the Act. In these types of cases, you do not need to prove an intent to discriminate. There's no intent requirement. You don't need to prove an intent to violate the Act on the part of the employer. You only need to prove that the Act was violated. So those types of cases, because you don't have to prove the element of intent, are generally considered better cases and good cases under the Family Medical Leave Act. So when you're analyzing your claim, think, what exactly are you claiming the defendant did wrong? Did they discriminate against you in some way by denying you some privilege because of your taking benefits under the Act, or did they deny you benefits under the Act themselves? That's a key distinction, and I hope this information helps. Have a good afternoon. Bye-bye.